mention item number 14. With the consent of other side, my lord, I'm praying for adjournment of this matter for today.
14.
Yes, ma'am.
I'm for the petitioner here. ma'am.
Any objection?
Oh, I have no, they were supposed to produce the records. ma'am.
Yes, madam. The records are not available with us, madam. That
When
is-
can you produce?
Records for this is matter related to service. madam.
When can you produce?
Records, my lord. By
When?
after vacation, my lord, any date may be.
You want a date?
Can it be? Look, it's a long, old matter, ma'am, 2016. matter.
As paid for by learned counsel for the department and not objected to by the other side. List the matter again after the vacation on 24th
20.
April
Come up, like-
2025. Learned department counsel shall produce the departmental records on the next date.
Grateful.
Yes,
Wait, please, Lord.
yes.
My lord, with the consent of the other side, my lord, I beg to mention item number 13, my lord. In fact, this matter was earlier dismissed for default. It was restored very recently.
Okay,
I returned back the records, my lord. Therefore, it will also take up any day after the vacation. my lord. I have taken the consent of the other side.
okay,
Acha, I'm for the petition.
okay. Okay, as paid for by learned standing counsel, FCI,
Lordship,
Mr. PK Roy,
Lordship.
senior counsel. And not objected to by the other side. List the matter again after the ensuing vacation on 24th 24th of April. Yes,
May I plead your lordship?
hearing.
I beg with the consent of the respondent, I beg to mention item 19. Lordship, actually this matter come after a long time. And at the time of filing this writ petition, the petitioners for retirement is only one year left. So I want to need instructions regarding the present status of his service, lordship. So I need
19 item.
19. I need 4
You are
weeks
for the
time.
petitioner
Yes, lordship. I need 4 weeks time, lordship.
and who is for the other side?
I have taken consent, lordship.
Your good
Yes,
name?
R. Kakoti.
Miss R. Kakuti? Yes. Miss R. Kakoti, learned counsel for the petitioner, submits that she may be granted 2 weeks' time, 4 weeks' time to obtain up-to-date instructions from her client to find out whether cause of action still exists. Full stop. She submits that she has taken the consent of the other side as well. To stop in view of above, matter stands adjourned for 4 weeks. All right.
My lord, in item 13, can it be 22nd when instead of 24th?
Okay, 22nd.
May it please your lordship.
Item 14, 22nd.
May it
Yes.
please your lordship. I beg to mention item number 9, lordship.
9.
We have filed a affidavit in opposition on 29/3, lordship.
Oh.
The affidavit is not on record. I may be allowed to call for the affidavit, lordship.
Yes, let it be called. When did you file?
29/3.
On 29/3. Okay, let the affidavit be called. Item 9, 8 and 9, isn't it?
9.
8, 9, 10.
I am for
matters.
9. I am for 9.
You're for 9. You're for the petitioner.
No,
You-
lordship, I affidavit in opposition for the
You're
respondent.
for which respondent?
For
You're
the
CGC?
CGC, lord.
You're CGC.
No, I am not CGC. My senior is CGC.
Okay. So CGC has filed the affidavit.
Yes.
Okay,
lordship.
right.
Obliged.
May I please?
Yes.
Lordship? I beg to mention item number 15, lordship. Conducting counsel and her is not keeping well.
Okay. So,
Matter may be adjourned today, lordship.
okay. Mr. M. Dhar Lanet, counsel for the petitioner, is said to be indisposed. On a prayer made on his behalf, matter stands adjourned for
Adjournment. He's not keeping well, lordship.
adjourned for 2 weeks.
Okay,
2 weeks.
after we.
Yes.
May it pleases your lordship. I beg to mention item number 4.
Hmm.
I am appearing on behalf of M. Ahmed. Because of it, he has gone to his native town, so he couldn't come back today. So adjourn for the day, and if the matter can be fixed this week only, lordship, as per
Mhm.
lordship convenience, lordship. I have taken consent of other side.
Will it come up after a week then?
Yes, lordship, next week. I humbly pray for fixing a date, lordship.
Mr. M. Ahmed, learned counsel for the petitioner, is said to have some personal difficulty to appear before the court today. So upon a mention made on his behalf and not objected to by the other side, list this matter. Again, next Tuesday, date on 22,
No, next Tuesday.
next Tuesday,
No, 8th of April.
on 8th of April, 2025, as paid for.
Deeply obliged.
All right.
May please lordship, with due consent from the other side, I beg to mention item number 17, my lord.
17,
My lord, we are newly engaged counsel. I pray for a time to file our bagat numang, my lord.
how long, how much time do you want?
We are filing today, my lord. I
And,
pray that matter may be adjourned for a week.
okay, Miss
P. Wapangla.
P. Wapangla, learned counsel, submits that he has been recently engaged to appear on behalf of the petitioner and submits that she may be given a week's time to prepare the matter. To stop, she also submits that she will be filing her power during the course of the day. In view of above, the matter stands adjourned for a week.
Obliged.
I'm for the respondents.
Ms. B. Sharma, learned CGC, appears for this respondents. Yes.
May I please also, my lord, I beg to mention for listing, my lord, pending petition since 2022, my lord.
Why don't you mention it before the other court? Court number 5. Okay.
May I please the lordship?
Yes.
For item number 12, my lord, actually my senior is out of station for treatment in Chennai, my lord. Due to unfortunate reason, she is unable to appear today.
Item 12,
Item 12,
you are mentioning on behalf of?
respondent, my lord.
My lord, I have a small objection, my lord, in this case. This is a matter I have
No,
filed.
just a minute, let me listen. You're mentioning on behalf of the respondent.
Respondent,
Respondent is what? Petitioner.
a petitioner, my lord.
Respondent is petitioner.
Yes,
I is
actual-
for stay vacation.
My lord.
they have filed for stay vacation. It has
Ah.
already been decided earlier.
so
One
why
IA
do-
has already been decided earlier, my lord.
Huh?
One IA has already been decided earlier. This is the subsequent IA they have filed for
What is
vacating.
the earlier IA?
One IA was there for vacating the stay.
No, my lord, he is absolutely wrong. One IA was filed by the petitioner for extension of the stay order, my lord. And now this IA presently has been filed by the FCI.
You are appearing on whose behalf?
For respondent, my lord, for
It is
IA,
for the
right now,
petitioner, my lord.
petitioner I am.
No, you are the counsel, conducting counsel.
Yes.
Yes, my lord.
Are you the conducting counsel?
My senior is the conducting counsel. I am
Who's your
also-
senior?
M. Kumari.
Huh? M.
M.
Kumari.
Yes.
Okay, so what is the difficulty today?
She is right now in Chennai for treatment, my lord, for urgent basis. Right now, today, she is unable to appear today before this honorable.
When she'll be able to appear?
Within this week, within the next week, my lord.
This week or next week?
She said that it will take hardly 2-3 days more. She will be there.
No, you have to be definite.
On the next week, my lord.
Because the other side is pressing hard for
Yes, my
hearing
lord.
the
My
matter.
lord, on the next week itself, no problem.
Because stay is in your favor.
Yes, my lord. Absolutely.
So they are having difficulty. DP
lord.
was stopped,
My lord.
the department proceeding was stopped, You want to
Yes.
go ahead
Yes, my lord.
because there has a stay order.
Yes, my
There's
lord.
a stay order.
The similar facts and circumstances identical one, my lord. That is the reason the stay has been given.
That will have to be looked into, how similar it is,
My lord, my lord.
whether the witnesses are same, whether procedure is same, and whether same identical facts situation. You suggest a date?
My lord,
On 8th of April, yes,
Yes.
Tuesday,
Huh?
8th of April.
8th of April, no adjournment
No,
that
no,
day.
no,
Okay.
absolutely.
A mention has been made on behalf of Ms. M. Kumari, learned counsel for the respondents stroke writ petitioner. On the ground that he is presently undergoing medical treatment in Chennai. To stop, the said prayer is objected to by the learned counsel for the
FCI.
respondent FCI. Stating that the stay granted by this court and which was further extended should be vacated. As the department is, as the FCI is facing difficulty to stop. Considering the submissions made, let the matter be submissions made and as agreed to by the parties, let the matter be listed on 8th of April,
8th of April.
8th of April 2025. it is made clear that no further adjournment will be granted on that day.
My lord, interim may be extended till that.
Interim orders passed earlier shall be extended till that date. Please ensure that you conduct the case. If M. Kumar is not there, somebody should come.
Yes.
Okay.
May it please your lordship. In this matter, we are supposed to make certain payments under the head of leave salary to the petitioner. Otherwise, matter has been decided, we are supposed to pay.
Hmm.
Now, we have been able to pay 50%,
Hmm.
and the rest 50% we seek for some more time because of paucity of fund. If I may just submit this communication that I have.
But you see the last order.
Yes, lordship. No, we are bound by that. We are bound by that.
What about the interest?
That's what I'm saying, lordship. We are bound by the interest now. Because we have not filed a review or an appeal against this order.
Are you praying for a definite time, specific time, or just some more time?
The lordship will kindly just have a look at this communication that I have. However, it is contemplated to release the balance amount within a short period. The difficulty is, lordship, the paucity of fund. Otherwise, there is no pleasure with the authorities to keep the money withheld.
So,
They are in a serious financial crunch, your lordship. The balance amount is now around 52,000 and odd. And I have made it very clear to the clients also, this 9% will be binding upon them.
see, short period of time means what?
I asked them, they are saying there is no fund. So therefore, if I may pre-lordship, 2 months time, lordship, another 8 weeks time.
Mr. Pai,
Your lordship may give a specific deadline, Malad, then probably I'm not claiming the 9% also. If they paid Malad by 2 months.
2 months. 2 months. Please write down. Parties are represented by the respective councils. So, despite the order passed on 30/9/2024 for clearing the leave salary dues of the petitioner,
Amrit Kolita.
Mr.
Amrit Chandra Kolita.
Your A.K. Kolita.
Myself,
A. Kolita.
I am A. Sarva,
Mr. A. Sharma, learned counsel appearing for the
respondent 1 and 2, lordship.
respondent number 1 and 2 submits that he has been instructed to seek some more time since there is paucity of fund. Stop. In support of his submission, the learned counsel has produced a communication dated 31/3/2025, which states that a sum of rupees 50,000 has already been released to the petitioner on 7/2/2025, and the remaining balance could not be released due to paucity of fund. Stop. However, it is stated that the contemplation is made to release the balance amount within a short period. Stop. Considering the submissions made on perusal of the communication produced before the court,
First week of June.
we'll give a date.
Yes,
Yes.
first week of June, any date, first week of June.
Let the matter be listed on 5th of June
Yes, your
2025.
lordship.
The respondent numbers 1 and 2 shall ensure payment of the same. Payment of the balance amount to the petitioner on or before the next date, failing which court may consider passing further consequential orders. Okay.
Yes, your lordship.
Copy of the communication dated 31/3/2025 is kept on record and marked as X for identification. Please impress upon your.
I am doing it,
that,
lordship. Now, at my level, I am doing it.
Okay.
Oblige, your lordship. Oblige.
May it please your lordship.
Yes.
So as per the last order, your lordship, the petitioner, the matter pertains to VRS dues of the petitioners.
Hmm.
Now 12 crores has already been released, your lordship,
Hmm.
and that has been paid through RTGS.
Now I have recently, yesterday I have got a instruction through WhatsApp. They says that the remaining 18 crores has been placed before the recent budget session. And it will be sanctioned within this financial year and it will be released by this financial year. The amount.
When is the budget session having?
It has taken place last month, Your Lordship.
Last month,
Yes.
already placed.
It has been placed before the budget, Your Lordship. We have,
Has it been passed?
it has been passed, but it has not been sanctioned so far, Your Lordship. Once it's sanctioned, once the amount is released, we are ready to pay, Your Lordship.
Okay, and what is the formality required for sanctioning?
Lordship, the cabinet will approve it, and once it's approved, it will be sent to the finance department, then it will be sent to the treasury, Your Lordship.
So that would take how much time?
It will take at least 2-3 months time, Your Lordship.
2-3 months time. What is this amount? This is area salaries or VRS?
Area salaries, my lord.
Area salaries.
Area salaries.
But why does the VRS concept?
Lordship, because
Okay.
the spinning mill, it was shut down way back in 2006 itself. And it couldn't revive, Your Lordship. And thereafter, the government took a policy decision to close the entire mill, Your Lordship.
Okay.
And then, Your Lordship, the VRS has been given to the petitioners, Your Lordship. And that it has been unanimously accepted by the petitioner, Your Lordship.
Okay, we'll have a date in June.
Yes, Lordship.
Parties are represented by the respective councils. First of the matter pertains to non-release of the balance amount of area salaries of the petitioners, which runs into 18 crores, 18, huh? Stop. Out of the total amount of approximately 30 crores, 12 crores have already been granted by the finance department, leaving a balance of 18 crores. Your good name?
G. Bodley, Lordship.
Mr. G. Bordoloi, Learned Counsel, appearing for the
Standing counsel for the Corporation Department.
Corporation Department, submits that the balance amount has been passed by the recent budget session, but the sanction has not yet been accorded. Stop. He submits that once the sanction is accorded, the matter will be moved to the finance department for making the fund available. Stop. The Learned Counsel submits that the said process will take at least 2 months' time. Considering the above and the prayer made by the Learned Counsel for the Corporation Department, let this matter be listed again on 26 June
Lordship.
2025. The Learned Standing Counsel, Corporation Department, shall impress upon the respondent authorities to release the due amount to the petitioners on or before the next date fixed.
Lordship.
Lordship, my senior, Mr. H.K. Das, is on legs in another court. Kindly the matter may be taken up after some time.
Pass over? All right, pass over the timing.
Next week.
May I please, Lord? My lord, this
Yes,
relates to non-allotment of GPF account number, my lord.
GPF account number.
Yes, my lord. In this case, my lord.
Account number is given to whom? Those who subscribe the old pension.
Yes, my lord.
And those who subscribe the new pension,
They are not getting.
there's no account number.
Yes. My lord, in this case, similarly situated person, because earlier under the central sponsored scheme, 6 different institutions were established in the state of Assam in different districts, my lord. In those districts, 105 employees were appointed. In other districts, GPF account number has been allotted, but not in the case of Borpeta district. The GPF account number has not been allotted. Even
Okay.
in case of one person of the Borpeta district, he was allotted that GPF account.
One person.
One person has been allotted in the same district, but not in the case of the other persons.
So in the entire Borpeta district, only one person has got the
Yes, ma'am.
GPF.
But in other districts, they are getting those allotment numbers.
Now, who's for the department?
Department, health department has no objection. They have forwarded our case, my lord. And
Who's objecting?
Office of the
AG.
Yes.
AG, who's paying for AG?
He's on legs.
He's on legs. What is that? No, what is that? You tell me. You don't pass on the papers like that. Because if you don't read and analyze the situation and submit, whole day we'll be spending time reading each loose papers here and there.
Kindly, I'm calling my senior, just for pending.
Okay, you call him, but why you giving me that paper in the first place? Anything important there in the paper? Let him come.
Yeah.
Let the counsel come, senior counsel. First of all, for the time being.
That he cited authority. I can say. Attempt 6.
Item 6.
No, this item may kindly be listed after vacation, but there are some mistake in the petition. I have to file an additional affidavit.
Okay. As paid for by Mr. A. Dasgupta, learned senior counsel for the petitioners. List the matter again after the ensuing Bihu vacation.
In the second week of May, my lord.
You want a
Let
date?
it be after due vacation.
After Bihu vacation, I'm not giving a date.
Yes.
There are also one item, we both are there in item number 16, my lord. That this may also be come up after vacation, my lord.
16.
16.
Mr. Dasgupta is there also.
Yes, ma'am.
Regarding your additional affidavit, I don't think we need to mention. You can file.
No.
That
is what
liberty is always
I
there.
told him.
So similar order in item 60. After Bihu vacation.
Oblige, ma'am.
So Talukdar,
Lordship, in this case, Lordship, I have filed a word affidavit, Lordship.
you file affidavit.
Yes, Lordship.
See, one of your junior was giving me a paper. What was that paper? I don't know.
Lordship, on the basis of that
Huh?
paper, I have filed affidavit, Lordship.
Okay, what is that?
That is instruction, Lordship. I
Huh.
have filed that. Instruction is by way of affidavit. I have
Yes.
filed.
They want GPF number, account number.
Yes, Lordship, they want, but.
Why you are not giving?
Lordship, paragraph 4 of my affidavit, Lordship. They have joined in the service, Lordship.
What is the service?
Their service were regularized with effect from 19/5/2009.
No, just a minute. 19/5.
2009, Lordship.
What is the service?
Lordship,
Post.
Yeah.
What post?
post Lordship,
Grade 3 and grade 4, my lord.
How many petitioners are there?
14 per, my lord.
Grade 3 and grade 4.
Yes.
And all of them were regularized on this date,
yes, Lordship.
19/5/2009.
2009, Lordship.
So
So Lordship, with effect from 2009, if they are regularized, Lordship, they are not entitled to GPF account, Lordship.
paragraph number 4, you say?
Paragraph 5, Lordship, that regularization period, Lordship, page 55, running page.
55.
Yes, running page, Lordship, of affidavit, Lordship.
Paragraph 5.
Yes, paragraph 5.
But my page is page 54.
Lordship, paragraph 5, Lordship.
Please read.
Statement so and so, it is replied that services of the petitioners were regularized with effect from 19/5/2009.
No.
That affidavit, Lordship, filed by Lordship Nirmalamati Maishnam.
Just a minute. Filed by Dr.
Nirmalamati Maishnam.
Nirma. What is this? Nirma Das.
No, Lordship, that is filed by Lordship.
3.
Yes, respondent number 2. I am
You-
appearing on behalf of respondent.
Respondent number 2.
Yes,
Respondent number 2. Page number?
page no, Lordship,
I
paragraph
think
4,
something's wrong with the pagination.
page, Lordship, my page is 55, Lordship.
Out here is also 55, but
And,
it's
internal page is 3 of that affidavit also.
55 is cancelled. The new page number is 60. So paragraph 5,
Yes, Lord.
just read again.
Statements paragraph 13, 14 and
Hmm.
15 of 16 of the petition, it is replied that the service of the petitioners were regularized with effect from 19/5/2009 under state plan, and their posts were adjusted as per government of Assam by letter so and so so and so. Hence, their services would be treated as being regularized only with effect from 19/5/2009. Form number 3 and other connected documents for allotment of GPF accounts in respect of the petitioners was also not found enclosed with the Joint Director of Health Service Barpeta's letter number so and so so and so. As such, by letter number so and so so and so, the office has taken up the matter with the Joint Director of Health Service Barpeta to furnish the necessary documents. Next, Peter Lordship. They have cited some similarly situated persons GPF number has been allotted by the office.
No, before we go to the next paragraph,
Yes,
let us concentrate in paragraph 5.
yes,
Your case is that they were regularized only from 19/5/2009.
yes.
So if that is the case, then those who are regularized from this date
Yes, sir.
are to subscribe which pension? Old pension or new pension?
If they are regularized with effect from 2009, they will be definitely come under the NPS lordship.
Okay, what
So
about the
in respect of NPN lordship, GPF account number is not lordship.
NPS started from which date?
1st February 2005 lordship,
1st February
2005.
2005. Now, that is one of your stand.
Yes,
The other one, you said that there was some enclosure was not there.
yes,
You have taken up the matter with the joint director
yes, lordship.
on 13 April
And
2023.
Lordship, in the paragraph 17, Lordship, in the writ petition, they have stated that some similar situated persons GPF allotted has been issued by the Office of the Accountant General.
Hmm.
And in respect of that, Lordship, paragraph 6, Lordship, because that person's service was regularized with effect from 12/9/2002.
From the date of joining.
Yes,
No, but what about this, your letter to the joint director? What has happened to that letter?
Lordship, that instruction.
Let us read that letter, Annexure 3.
Yes,
What does it say? Annexure 3, but you mark it as ABC.
Lordship, that says, yes, 13 April letter, Lordship.
A equal to 1, B equal to 2, like that. 13/4.
Yes.
Please
To the
read.
Joint Director of Health Services, Barpeta, GPF account number allotment. In inviting a reference to your letter dated so and so, I am to state that this office is not in a position to allot GPF account numbers to the applicant of your office due to non-receipt of application and all necessary enclosures as mentioned in the following letter. Moreover, it is mentioned that in your letter that the services of the incumbents has been regularized with effect from 19/5/2009. As per Government of Assam Department of Finance budget wide letters dated 23rd February 2010 and letters so and so dated 10 March 16, it was specifically pointed out that all new entrant joining state government services on regular basis against vacant sanction posts on or after 1/2/2005 are covered by NPS. Thus, it implies that any government servant who is appointed on regular basis on or before 1st February 2005 or any government servant whose services had been regularized by the competent authority from a date of prior to 1/2/2005 will be covered by existing old pension scheme and will be eligible to join GPF as such subscriber. It may be stated here that in respect of so and so of GNM Training School Barpeta, this office had allotted GPF account number on the basis of application and regularization in service prior to 1/2/2005. As intimated by the DDO, white letter dated so and so, an order issued by the Joint Director of Health Service and closed.
Okay.
So that part.
Second part we have understood.
Yes.
The first part is non-receipt of application and all necessary enclosures means what?
They have sent for allotment of GPF lordship without any document, without any application. Only that covering letter was forwarded. That is stated lordship.
So what is the reply to the health department?
It's already forwarded, lordship.
When?
Can you kindly say?
Your affidavit?
Yeah. Instructions, lordship.
There's nothing much in this letter.
My affidavit, Lordship, which was filed on.
No, this letter which you passed over. This doesn't say anything much. It just includes one of the
Forwarded, Lordship.
regularization order, that's all. But it is the specific case of the AG that those who are regularized from this date, 19/5/2009, are not entitled to get the GPF account number. Only those who have been regularized prior to 1/2/2005 can be covered by the old pension scheme. Petitioners have been coming regularized after that date.
To forward applications, Lordship.
Now that understood. But why can't you regularize them?
Filed in my affidavit, Lordship.
Why can't you regularize them before 1/2/2005? When did you start your work, learned counsel for the petitioner?
My lord,
When did you join service?
2002, my lord,
2002.
2002, 2003.
Okay.
Some had joined 2002. Some had.
See, now your endeavor should be to get your regularization prior to 1/2/2005. If your regularization is after 1/2/2005, automatically you are covered by the NPS. That is your case.
Yes, my simple case is that there were 6 numbers of nurses training institutions, my lord. In other districts, they have been allotted. And by the order.
Now, if it's allotted, then it's wrongly allotted. If it's wrongly allotted, can you also make the same prayer saying that I also should be wrongly allocated? It has to be allocated as per the procedure and the rules. NPS is very clear. It comes with effect from 1/2/2005.
That is true, my lord.
Now your prayer should be to the department. Please regularize my service with effect from date of joining. Since you have regularized me only from this, what is the date?
19/5.
19/5/2009. I cannot get GPF account numbers.
That is reflected in Annex 13.
That
of
should
the
be your prayer. You have to challenge your regularization
Yes, my lord.
so far as the date is concerned, effective date. If you are successful, then they will have no excuse. They will have to give you the GPF account numbers.
In this case, by order dated 19 May 2009, altogether 105 employees were post-prayer sanction, including the other districts. After that, they have been stated that they were allotted, their posts were regularized prior to 2005. But in my case, they have not stated like this.
All right. So with the present prayer which you make in your writ petition,
Yes.
I don't think you'll be getting any relief.
My
You have to
lord,
challenge. You have to challenge that order,
my
saying that why you have regularized me from this date. See, Mr. XYZ, they have been regularized from this date. Therefore, they're getting the GPF account
my
numbers.
lord, in that case, may I pray for that to consider the department, to consider the case of the petitioners
No, no, no,
as
not like that. I think you should file a proper concise writ petition, saying that you should be regularized from this date. Because others similarly situated in other districts have been regularized.
yes, my lord.
I should be regularized, number one. After regularization, number two, that since my regularization is from this date, I should be given the new pension, old pension scheme. That will be precise. Otherwise, now what you're saying is that straight away you're saying, give me
Yes,
account number. They say that we cannot give you account number like that.
But my submission is that there is discrimination because in the present,
Exactly. So you reorganize your writ petition.
so in that case, I may be allowed 1 or 2 weeks time maybe to discuss with my client.
All right. I think that will be the best thing.
Yes, my lord.
I will not advise you anything, but it's up to you. In such a situation, one should, take back the writ petition and file one fresh one,
Yes. I will have to
giving
take
that with that prayer that I should be given equal treatment because this is Article 14-16 violation.
my lord, I will have to take instruction from
All
my
right,
client.
all right. Learned counsel for the petitioners submits that he needs 2 weeks' time to obtain instructions from his client. As paid for, matter stands adjourned for 2 weeks. You have a discussion.
Yes, my, may I have a paper fixed left, my lord?
2 weeks, give a date, please. Give a date for after 2 weeks.
24. Masuk.
Lordship, in item 7, I have received the instruction, Lordship.
Just a minute.
Yes, Lordship.
This was which item? The one we just saw, Code Master? Key number is later. 7. Right. Yes, item 7.
Lordship. Lordship, no reply has been filed. I have received instruction, Lordship. So I am praying for 10 days time, Lordship, so that I can file it the affidavit.
Is item 7, is it? Ms. M. Bhattacharjee, learned additional senior government advocate, submits that she has received the instructions and therefore prays for 10 days time to file counter affidavit.
Date may be fixed, Lordship.
Considering the prayer, this is the matter. On 11th of May, 2025.
Obliged.
Counter affidavit be filed on or before the next date with a copy to the other side.
Deeply obliged. Obliged.
Mr. Das,
Yes, my lord.
what is this matter?
Lord, at this stage, what I am praying is that regular pension, regularization of the suspension period, and there was a recovery, direction for recovery of an amount. There was no fault on my part or at my instance, the excess.
Recovery on the basis of DP?
No, no. Actually, what they have done, while granting the fixation benefit, my lord, they have erroneously given, multiplied it by 2.67, and it should have been multiplied by 2.57. So it was not my fault. So they have excess amount which was paid to me. They sought to recover that. So that aspect is covered by the Honorable Apex Court decision in Rafiq Masi, because the petitioner has already been retired from service. So that issue is squarely covered. Other two issues regarding regularization of suspension period is concerned, my lord. What they have done, they have initiated a court of inquiry pertaining to certain allegations. But that court of inquiry never culminated to a to issuance of a charge sheet. No DP was initiated. So in the meantime, I retired from service. So there was no charge sheet. So that period, when I was placed under suspension, I am entitled to full pay and allowances and regularization of that period. And my final pension has not been paid as of now, although there was no charge sheet against me. I'm still getting the provisional pension.
When did you retire?
I retired, my lord, 31/1/2020.
31/1/2020.
2020, my lord.
2020.
2020.
As
my lord,
IG, na?
IG.
IG.
Yes, my lord.
Which organization?
SSB, my lord. Sasastra Seema Bal. If I just take your lordships with the documents.
So
My
basically is that
case is that for the purpose of suspension and sorry, my lord, final pension, you cannot withhold the same without any charge sheet. That's a settled proposition of law, my lord. If you want to withhold my pension, then and give me provisional pension, then there has to be a charge sheet.
Here, my lord, there is no charge sheet. Only court of inquiry was held first, then additional court of inquiry that was sent to MHA, but thereafter no decision. So as on today, it's an admitted factual position that there is.
So decision is awaited or what has happened?
They just set over the matter since then, my lord, 2019.
19.
Yes, my lord. They just set over the matter.
And you retired on 31/1.
Yes, my lord. 31/1/2020, my lord. The court of inquiry was.
During your service, you were placed in the suspension.
Yes.
Court of inquiry was held.
Court of inquiry was held, but thereafter no charge sheet.
No charge sheet.
No charge sheet, nothing.
You said twice.
Sorry, my
Inquiry
lord.
twice.
Yes,
in-
first court of inquiry, then they again held an additional court of inquiry. Then they just set over the matter. No charge
No
sheet.
charge sheet. In the meantime, you had to retire.
In the meantime, I retired. They withheld my regular pension and granted me provisional pension, saying that court of inquiry was held.
Okay.
My lord, you cannot withhold my pension on the basis of court of inquiry, because court of inquiry is more like a preliminary inquiry. You need to have a charge sheet.
Okay.
Because DP is initiated, a departmental proceeding is construed to be initiated when a charge sheet is issued.
Hmm.
So that's how I am entitled for final pension.
Apart from the provisional pension, what else did you get?
Sorry, my lord.
What else did you get apart from provisional
My
pension?
gratuity and all those things were
Released.
not released, my lord.
Gratuity not released.
Those were also withheld.
What about leave encashment,
Everything has been withheld.
GIS and all that?
No, only provisional.
Only provisional pension.
Yes, my lord.
And how much is the provisional pension worked out as otherwise compared to a regular pension?
Provisional.
A certain percentage?
My lord, I'll just give. Look, I'm just giving the figure, my lord.
This B. Sharma is there for the other side.
Yes.
You file affidavit.
Pleadings complete.
Readings complete. Then what about the records? Is it required?
Records at present not, because you shall not call for.
Or will it be required? What has happened to the court of inquiry, an additional court of inquiry? Any pleadings to that effect?
Present status, after the affidavit, I don't have what happened thereafter, possibly, because they have also not intimated. At the time of filing of affidavit, which filed in the year 2022, Lordship,
1,05,000.
Your affidavit is of 2022.
yes, Lordship, my affidavit is of.
You don't have any up-to-date status.
Yes, I don't,
Now, generally what happens? Court of inquiry, additional court of inquiry.
Lordship.
Now, to culminate into a charge sheet, how long does it take? Is there any
Not
time prescribed?
The petitioner, it's not only one, so many facts are there in this petition, Lordship. Many other issues are also there. Maybe that is the reason why I can't say at that, but present status, I don't have. What happened and
You
after
have the
this,
status.
Lordship, I have at the.
I think let her have the status. We'll post it again with a very short date.
My lord, firstly, your lordship's query with regard to pension. He is getting 50% of the basic pay, last pay. That will come around 1 lakh odd rupees. 1 lakh plus
50%. Provisional pension.
provisional pension.
What about the regular pension?
Regular pension.
How is it worked out? It regular pension amounts to how much percentage?
Regular pension is worked out again at the rate of 50% and along with other
50%
of the last pay.
of the last pay.
Yes.
And provisional pension? Same thing.
Same they have given, but regular pension, my lord, the other things will come, my lord. Great pay and all, DNS allowance and all those things will come.
Some additional benefits are there.
Yes, additional benefits are there.
I see.
So, my lord, so far as charge sheet is concerned, it's absolutely clear that there was no charge sheet against the petitioner. And since 2020 he retired. Now we are in 2026. They have filed affidavit. In affidavit also they did not say anything with regard
Let us
to.
get the instructions. We'll give a date.
No,
Because before the court makes a decision or makes a call, let us have the actual status so that, like things are more clear.
Lordship,
My
yeah.
senior friend can take instruction whether charge sheet was filed or not, but their affidavit, they have filed.
Affidavit is of the year 2022, she says. I have not
Yes,
seen it.
yes.
So if that be so, then it's more than 2 years now. So we don't know what has happened. And normally it's come for hearing, so probably she'll also not be aware of what has happened.
Lordship, in my affidavit, I have stated that he had submitted a representation on 5/8/20 addressed to the Ministry of Home Affairs for granting regular pension, which we have forwarded to the ministry. That is in the year 2020. So, and
So you take instructions and all that also. What has happened to the representation? What has happened to the court of inquiry, additional court of inquiry?
Lordship.
And when is they likely to take a decision, or whether they're not going to take a decision? If they're not going to take a decision, why should you prolong his getting full pension? Isn't
Here,
it?
the DP is not under challenge. Do whatever you want. There is no challenge to the departmental proceeding or the court of inquiry. Here, the requirement of law is that if you want to withhold the
Correct.
pension
See,
under the pension rules, then you need to have a charge sheet.
correct. So court of inquiry has not culminated into a charge sheet, not no
Yes.
proceedings.
Yes,
Still, then they have given you only the provisional pension.
yes, madam.
Under what circumstance? Let us get the instructions. If they say that we are still thinking about it, then we'll see what.
Now also they cannot perhaps, subject to correction. Even now they initiated charge sheet. They cannot go for withholding because it was done in the year 2020.
Okay, please write. Heard Mr. H.K. Das, learned counsel for the petitioner, who submits that the petitioner retired as IGSSB on 31/1/2020. Stop. He submits that during the time when the petitioner was in service, he was placed under suspension, and court of inquiry as well as additional court of inquiry was conducted. But no charge sheet has been filed till date. Stop. Despite the same, the petition has been given only a provisional pension. Stop. The learned counsel submits that without there being a charge sheet, the respondent authorities cannot withhold the pension and other pensionary benefits of the petitioner in the manner it has been done. Next para, Ms. B. Sharma, learned CGC, submits that counter affidavit was filed in the year 2022. And as per the said affidavit, the respondents are yet to take a decision on the court of inquiry as well as on the additional court of inquiry conducted. To stop, she submits that the representation of the petitioner for payment of regular pension has also been forwarded to the Ministry of Home. Which is the competent.
And we had given him reply also in the year 2021. So that part,
Authority to consider the prayer of the petitioner. Stop. Next para, having regard to the above projection, and in view of the fact that the affidavit opposition was filed as far back as on, what is the precise date?
This was filed on, my lord.
3/8/2022.
3/8/2022. Learned CGC shall obtain up-to-date instructions as to what has happened to the representation submitted by the petitioner, and also what decision the respondent authorities have taken pursuant to the court of inquiry and the additional court of inquiry said to have been held against the petitioner. Stop to enable the learned CGC to obtain instructions. Let the matter be listed. Again, after
Vacation.
22,
Vacation.
my lord, it was
2 weeks or 3 weeks. Today is first.
20
After 3 weeks,
22nd,
list the matter again on 22nd of April 2025.
my lord.
Learned CGC to obtain instructions by them.
Lordship, one thing that representation, against his representation, we have replied. But present status, I don't.
Okay, anyway, obtain the status. We'll take care of that in next
Well,
meeting.
Highly obliged.
Eight, nine, 10, all these petitioners, my lord, they are serving as riflemen tradesmen in the Assam Rifle.
You are on this side now.
My lord,
You were on that side earlier.
earlier I was this. Yeah, they are, my lord, barbers, safaiwala, carpenters. Earlier they used to be called Group D. Now they have been equated to Group C.
They're called Group C.
Now everything has come into Group C in the
Group C.
my lord.
Group C includes what posts? Barber.
Barber, safai, carpenter, and EBR. EBR is booth repairer.
Safai, then
EBR is booth repairer, my lord.
EBR.
EBR, yes. Equipment and booth repairer, EBR.
EBR.
Yes. my lord. And carpenter.
Carpenter. 4 categories.
4 categories, my lord.
They come under Group C.
My lord. As of now. Earlier they were D, my lord.
Earlier they were D.
My lord. Now this CCS, I think, has recategorized most of this Group D services as Group C services, my lord.
Earlier they were D.
My lord.
And earlier they could be promoted to Havildar.
Before 2003, they would be promoted to Havildar. But then in the 2003, my lord, what they call the RPE.
Conversion from D to C came in 2003.
No, it came subsequently, my lord, after 2006, my lord. That is not the issue, because that the renaming of C to D, my lord, has not changed our jobs, or it was not having any effect on our pay also, my lord. The grievance is that, my lord, the promotional revenue to Havildar for these riflemen was there till 2003. In 2003, my lord, this system was abolished.
Then after
my lord,
abolishing, what remains for you?
we remain riflemen lifelong, my lord. But then we remain riflemen lifelong, my lord.
Riflemen?
My lord.
But you are barbers, safaiwalas, and EBRs and carpenters.
My lord.
They are also called riflemen.
My lord. Everybody is competized, my lord, these days. Everybody is competized.
They are riflemen.
Yes, everybody is competized.
They handle weapons also?
Yes, my lord.
Carpenters also handle
my lord. And they are given training at least. My lord.
They're given training.
If they are not even put in the active.
So what is your grievance?
The grievance is that, my lord, subsequently what happened that the other paramilitary forces that are under the Ministry of Home, they had introduced this post of head constable or havildar in BSF, SSB, ITBP, CRPF, my lord. Everybody has introduced this post. As far as Assam Rifles is concerned, my lord, it is still in the proposal stage, my lord.
No, they have introduced what?
The post of head constable or havildar has been reintroduced in the other paramilitary forces under the Ministry of Home Affairs.
Head constable and havildar same?
Same, my lord.
So in respect of the other paramilitary forces, this is there, except for the Assam Rifles.
This has come. But then as far as our cases are concerned, they say now, my lord, in the affidavit it's revealed. If your lordship takes up the first case, my lord, at page 75.
Your basic case is for promotional avenue.
My lord.
Promotional avenue.
Basically a cadre review, my lord.
Cadre review.
Basically a cadre review. Now, in page 75, the affidavit says, more or less our case is, my lord, considered here, but then it is said to be considered, not actually considered. Page 75 says that cadre review of the force has also been undertaken by the Assam Rifles, and the proposal is under consideration of the ministry. Once the proposal is approved by the Ministry of Home Affairs, promotional avenue up to the rank of havildar will be granted to the petitioners at par with other CAPFs. So now, my lord, what remains is that I understand it's under scrutiny, but then it cannot be under scrutiny forever, my lord. Since 2014, they said that this proposal has been routed and rerouted, my lord.
When was this affidavit filed?
This affidavit was filed, my lord, on 19/12/2024.
One affidavit is filed today.
Same thing, with same thing, with same stand.
Same thing, item number 9.
So this is under consideration as
My
per
lord.
the affidavit filed on 19 December 2024.
My lord.
That is about 3 months back.
My lord. Now, the other affidavit, in fact, also says that proposal given 2014, and from 21, this current proposal is still, my lord, in the stage of consideration.
But what are the details about the consideration? This is a bit general, isn't it? It's
Yes, my
under
lord.
consideration.
Yes, my lord. No, they
We will look
admit,
into it.
they admit that we are going to introduce this post of Havaldar at par with the other paramilitary forces. So it is a clear case that other paramilitary forces already have this avenue. But then as far as Assam Rifle, which is also under the same ministry, this avenue is not there, and therefore it has to be introduced. There cannot be disparity between the paramilitary forces under the control of the same.
Promotion was there in the prior to 2003.
It was there. Then it was taken away. Now, as far as cadre review is concerned, my lord, the guidelines say that every 5 years it has to be carried out, because every force or every working
5 years will start from which date?
Every 5 years, my lord, from the date of, my lord, the recruitment rules coming into force, my lord.
So what will be that date out here?
Here, my lord, the extent recruitment rules came in 2006 as annexed by them. 11 they were supposed to review, then 16 and 21. 21 days started the review proposal, my lord. And now it's going to be 26, this 5 years review proposal, my lord. It's almost time is going by.
Mr. Pathak, what can be done in this case?
But in fact, we had filed a similar case, my lord, for the Group A officers, my lord. This honorable court had said that because ultimately, my lord, cadre review is a matter of policy. The government may consider something, may not consider something. But then they should at least take our grievances into consideration and complete the cadre review exercise, my lord, within a particular time frame. So as far as Group A is concerned, my lord,
So we close the matter with an observation then.
My lord, my lord.
What do you say? Let's close the matter with observation.
My lord, the Group A officers, my lord, 10 months time was granted by this court, my lord, to complete the exercise.
In their case, 10 months is a long time. 2 months?
2 months.
6 months, my lord, I understand.
Time document immediately, 2 months time. Then we will be taking that. It's pending law.
2 months will be over in Bihu vacation. Isn't it?
I think 6 months would be reasonable, my lord.
6 months.
Cadre review structure, I understand it's complicated, my lord. The extent circular for Group B and C, my lord, is this one, my lord. And for Group A, my lord, a similar order was passed, my lord.
But what has happened to Group A now? When was
Group
that
A
order?
also, my lord, this order came last month. Court had granted 10 months time, my lord, because
First, if the earlier one is pending for 10 months, but here also not paper same time of with some same time.
No, see, if the process is to be initiated from right from the beginning, then okay, 10 months, 1 year. But here you are saying, your affidavit says that it is under consideration.
from 21.
That means you are seized with the matter. Other organizations, BSF, CRPF, they're getting this. So only thing is that somebody has to decide, the cadre review has to decide. So 6 months is, I think, quite
My lord.
reasonable.
For A, my lord, there is complications also. Officers level, my lord, there are a lot of complications. But then for B and C.
So
my
the
lord,
order will be very brief on facts.
My lord.
I don't think we have to make
My lord, we
a
will
round
not
about
explain.
all the observations,
My
isn't it? Please write down. I heard Mr. B. Pathak, learned counsel for the petitioners. Ms. P. Sharma, learned CGC, appearing for the respondent Union of India.
I'm in item 8.
Just a minute. B. Sharma, in WPC number 4424/2024. And Mr. K.K. Parasar, learned CGC, in WPC number 3273 of 2024. And Mr. M.R. Adhikari, learned CGC, in WPC number 4423 of 2024. Only 3 cases, isn't it?
3 cases.
Most of the petitioners in all the 3 red petitions have a common grievance. which is to the effect that they are currently placed under the Group C category in the Assam Rifles and are appointed as riflemen. No, and are appointed under different categories such as barber, safai only or safai wala,
They call it Safai only.
safai, comma, EBR and carpenter. Stop. The petitioners are otherwise all termed as riflemen in the Assam Rifles. Stop. The basic grievance of the petitioners is that they have no promotional avenue. Unlike the other paramilitary forces such as BSF, CRPF, etc., which has the promotional avenue as head constable or havildar. Stop. According to the petitioners, prior to 2003, those working in similar trades had the opportunity to be promoted to the next higher post of havildar or head constable. But the same has been stopped since then. Next para. Against the writ petition, the Respondent Union of India have filed their counter affidavit. And in paragraph number 10, it has been stated that cadre review of the force has also been undertaken by the Assam Rifles, and the proposal is under consideration with the Ministry of Home Affairs. So once the proposal is approved by the ministry, promotional avenue up to the rank of havildar will be granted to the petitioners at par with other Central Armed Paramilitary Forces.
I think it's called police forces.
Police. Okay, police force.
Armed police is paramilitary.
Okay.
In my estimate, I have said this, but the approval is final still in with the Ministry of Finance. In my para 10. In item number 9, para 10, page 63.
Give me item 9. WPC 3273. Oh, it's here. Okay. Paragraph 10.
Paragraph 10.
Second, Zuna. Copy of the reader. I sir.
Next para, the Respondent Union of India in WPC number 3273 of 2024 have filed a counter affidavit on 29/3/2025, wherein at paragraph number 10, it has been stated that a cadre review proposal was submitted to the Ministry of Home Affairs in the year 2014, 2017, and finally in 2021. And the current proposal is in the final stage of approval with the Ministry of Finance. Next paragraph. Considering the above developments. No, cancel that again. Next paragraph. At this stage, it is submitted at the bar that a similar case, but in respect of Group A officers in the Assam Rifles, had been disposed of by this court by order dated 27/2/2025. And the case being WPC number 259 of 2021. By granting the respondent authorities to process the gather review within a period of 10 months from the date of receipt of a certified copy of the court's order. So, therefore, having regard to the grievances projected by the petitioners and the fact that the matter is being processed and currently with the Ministry of Finance, the writ petition is disposed of, by directing the respondent authorities to complete the process of gather review as expeditiously as possible and preferably within a period of 6 months from the date of receipt of a certified copy of this order. Did I say dispose of? I said, yeah, hold on. Yes. Quickly. Cost list. Yes.
Please, Your Lordship, my lord, there is a order under review, my lord. And the order passed by, and this order under review was not passed by Your Lordship, my lord. It was passed by my Lord Justice N. Koteswar Singh when Lordship was here.
Okay.
And my opening statement would be,
Yes.
Lord, there is no mistake script in the judgment. There is no mistake script in the judgment. Even then, I am under review because of a technical reasons. This
Yes.
thoughts and compass of the whole thing is this. I'm a pediatric surgeon I was working in GMCH. One of the best pediatric surgeon, Dr. Manoj Saha, in the northeastern states. He was working in this under the Guwahati Medical College and Hospital as an assistant professor, then associate professor since 1989.
Okay.
For some reasons, he resigned from his service in the year 2016. But pediatric surgery is a very rare and is a department which needs doctors having superfine expertise.
What surgery is it?
It's a pediatric surgery. Surgery of child.
Pediatric surgeon.
Pediatric surgeon.
Pediatric surgeon.
Yes, he is a
Okay.
pediatric surgeon. So he was not released from the service despite his resignation in the year 2016.
Okay.
Then he worked till 31st July 2018.
Okay.
Since the department was transferring him from Guwahati to outside very frequently. So actually for that reason, he resigned in the year 2016. Thereafter, he was working, since his resignation was not accepted, he was working till 31st July 2018, and he has been paid.
Okay.
So when he was not released from the service, even after July 2018, he filed a writ petition before this honorable court.
Yes.
Seeking a relief that accept my resignation.
Okay.
This was his prayer. There was a statement made in the writ petition event that after my resignation, whatever my benefits, because I am working in government since 1989, I have to get it. So, my lord, if lordship can see at page 31, paragraph number 10, this is the paragraph number 10 of the writ petition.
Yes.
If I may read, my lord.
Yes.
That under the facts and circumstances stated above, your lordship may be pleased to issue a writ in the nature of certiorari in setting aside the quashing of MP notification issued by the Joint Secretary Government of Assam Health and Family Welfare Department dispute regarding transfer of the petitioner from the post of Associate Professor of Pediatric Surgery GMCH to the post of Associate Professor of Pediatric Surgery Assam Medical College Dibrugarh, and be further be pleased to issue a writ in the nature of mandamus directing the respondent authorities, particularly the Commissioner and Secretary Government of Assam, Health and so and so dispute to dispose of the resignation letter dated 5/7/2016 submitted by the petitioner before the Commissioner and Secretary Government of Assam, Health and Family Welfare Department dispute, and thereby resigning from service by the petitioner from the post of the Associate Professor of Pediatric Surgery, Guwahati Medical College, Guwahati, with arrear salaries and other service benefits paid to the petitioner in accordance with the rules up to date under the facts and circumstances of each case of the case in the interest of justice. Otherwise, your petitioner will suffer irreparable loss and injuries. Despite these pleadings, my lord, inadvertently, the counsel who conducted this petition on behalf of the petitioner, he said that I don't need anything. And this honorable court was rightly, because since it was submitted by the lawyer, it was recorded like this, my lord. And what has been, now why I am before your lordship, my lord, for two small reasons, if lordship can read it, my lord. Just to expunge two sentences from this judgment, that your lordship may find it page 47.
Yes.
Paragraph 12. Now. Since the petitioner has sought resignation without seeking any benefit from the state, and since the petitioner has submitted his submission application, it should be resignation application from resignation as long as 5/7/16. This court is of the view that there is no reason why government should not accept his resignation. So and so. From this paragraph, my lord, if lordship pleases now that he may be given all his service benefit after resignation as per law, as per his entitlement. If he is not entitled to anything, he will not get anything. But it is not correct to say on the part of the lawyer to say, while there is a pleadings contrary, that we cannot submit or we cannot argue anything beyond the pleadings, my lord. This is a settled proposition of law. The pleadings that I have shown to your lordship, that I prayed before, I have a pleadings, said before the court, that after resignation, whatever is entitled to me, that may be given to me. One. Next paragraph, my lord, that resignation was to be accepted from 5/7/2016. Actually, in next paragraph, accordingly, the present petition is allowed, the petitioner shall be deemed to have resigned with effect from 5/7/16. It should be 31/7/2018. Because I worked till 31/7/2018 and I have been paid for this. These two things, if lordship makes the correction, my lord, not exactly correction, this was beyond the pleadings submitted by the lawyers. There's a fault on our part, fault on the part of the bar, my lord. And since the law is settled, my lord, that we cannot go beyond the pleadings, and the petitioner never instructed this to the counsel, that say that I don't need anything. My lord, even if I say I don't need anything, since 1989, I have submitted my PF, my lord. My PF default money is there. I may not be entitled to gratuity or leave encashment since I have resigned. But my PF money, my lord.
But what about your review? When was it filed?
Pardon this, my lord.
Your review.
This petition.
When did you file it? 2024. Order was passed in 2019. 20,
We filed a
21,
review in
22,
2022. 22.
After 5 years, you are filing this review
My lord,
with a second thought.
my lord, what my respectful submission on this, my lord. In general, even in writ petitions, my lord, review time limit, my lord.
No. I'm not saying about the time limit.
Okay,
Although
fine.
we
Yes,
may,
yes, I understood. Lordship would like to say that this
if
is.
you say that this was not my instruction, under what circumstances my
My lord,
lawyer has
what-
submitted,
What my.
why not immediately
Yes, correct, my lord. That is, Lordship is 200% correct on this.
200%?
Because of the fact that this person remains busy in, my lord, in medical treatment of the children's, my lord. And that part of his job is a very, very fragile and very, what should I say? It's a very delicate jobs. And I had that occasion to meet him.
No, don't give me your personal interaction with you. You
No,
tell
no.
me what statement have you made for coming for review of 2019 in 2024. I'm not saying anything on delay. I'm just wanting to know I just want to know what excuse you've made.
Excuse is not exactly, my lord. He thought that he got the resignation accepted. He will not be entitled to anything. But when he discussed with me, I said that after the removal of these two sentences, if you are entitled to any relief, so far as service benefit is concerned,
You have not given any explanation.
no, my lord, not exactly an explanation for this, my lord. But what prayer I am making right now, my lord, this is innocuous, my lord. Because the fact remains, my lord, two things I pray for a correction of two things, my lord. One, the date of effect of his resignation.
No, that I've understood.
And second thing, my lord, if I am entitled to any benefit, service benefit, after the resignation, that may be allowed to me in accordance with law.
So what happened to your resignation then?
Then
Was it accepted?
Now it is accepted.
When was it accepted?
It was accepted, my lord, on 25th, sorry, 25th November 2021. So I came to the court in 2022, my lord.
Resignation accepted from which date?
This resignation was accepted on 5/7/16 with effect from. I came to the court after this order. November 2021, this order was passed. Lordship may see here page 49. And I approached this court, my lord, for review of this order, June 2022.
So 5/7/16 was the date of your application for resignation.
Yes.
So that date is taken as the date of resignation.
Because there is an order from this court. There is an order from this court to accept the resignation date with effect from that order, that date. That is why it was made effective from this.
This is as per your prayer.
Yes.
Order was passed as per your prayer.
No, my lord, the prayer was this, my lord, when the petition was filed, my lord, I filed this petition after filing the resignation. I resigned in 16. It was not accepted. I kept on working in the department, getting the salary 31st July 2019. Sorry, 18. I approached this court in 2019 if I accept my resignation. But it should be accepted from that date till date I'm working on.
So that
It's a
was not
factual, my lord.
No, I've understood. See, you submitted resignation on certain date. Now, no action was taken. You kept on working, and one fine day you filed a writ petition. Writ petition was taken up for consideration, and court said, okay, you had submitted your resignation on this particular date. They should consider and accept it. And if they don't accept it, he'll be treated as to be resigned from this date. So that order was passed way back in 2019, and it continued to exist. There is no such kind of appeal, review, revision, nothing. Then one fine day in 25/11/2021, resignation was accepted from this date.
If I may submit.
Then you file review. That also not immediately. You file in 2024.
No, 22, Miller. This
Review.
Yes, this review petition is 22.
Or 22, okay.
This, my lord, acceptance order was published on November 2022. 21, sorry. November 2021, acceptance order. And I filed this review in June 2022. Well, from that aspect of the matter, my lord, I believe the delay is considered, delay may be considered, my lord. Maybe the delay in approaching to review the order may be taken care of from that perspective. That since the acceptance order was passed in, the fresh cause of action for review is on November 2021.
So, if you are not happy with this order passed in 2019, what stopped you from coming back to the court saying that, no, this has to be rectified? I never instructed my counsel to make this submission.
That part is there. I cannot.
That you have not done.
Now cannot I improve upon this. But the fact remains.
After getting the order, then you said, oh, I should not have said this.
Yes, my lord.
I should not have said that.
Sometime.
Then you come back.
Well, but coming little late to this court, honorable court, my lord, this will not wipe out my right to getting it correct, my lord.
But where's the explanation for the delay also? Review has to be filed within 30 days.
My lord, in case of writ petition, my lord, it's not applicable, my lord. Directly the spirit.
There is a reported case.
Arunachal case.
There is a reported case. In fact, your lordship says this one review filed by the NSM, where I appeared for the review applicant, and it has been dismissed. This was a ground lordship has taken into consideration because we preferred it about after 1 year or 2 years.
No, what is the judgment?
So
That review is not applicable.
Well,
I can praise lordship judgment.
there are contrary judgment also. What I have come for your lordship, my lord, I have not sought for anything to be reversed.
I understand,
but my lord will appreciate.
You file review.
High Court is a.
You don't want.
My lord, High Court is the first court of records.
You say that there's nothing wrong with the order. Firstly, you say there's nothing wrong with the order.
Yes, of course.
Secondly, you say that the order has to be corrected.
No, there is no wrong. The mistake, my lord, wrong and.
So giving a take in both with one hand.
No, it's not that.
Giving one take.
What I'm trying to say, impress upon your lordship is that High Court is the first court of records. If there is something recorded which is not on record or contrary to record, that must be corrected first. I may seek a remedy in a higher forum going against this judgment with an appeal. It's a different thing altogether. None can stop it from. But my duty as a counsel to this particular person to advise him to approach the court for a review to record this date, to make a correction of this date. Since this person, fact remains, there is no denial of this fact that this person worked till 31st July 2018.
No, that's why you should have come immediately saying that I've never instructed.
I understand. I bow down to this, my lord, that I am late.
So presumption is there now that you were all along playing along with this.
My lord, what I am praying for, even if I am late, but what I am praying for is innocuous. What I am praying for is innocuous. This will not cause any hindrance anywhere, any side. I work till their fact remains. This is correct fact that I worked 31st July 2018.
Have you questioned your counsel?
Inadvertently, this has been recorded as this date.
Have you questioned your counsel or what, on what basis you have made the submission? I did not tell you.
That makes no sense otherwise.
Why
because-
not? Why not? That statement should come here. Petitioner has also questioned this counsel, on what basis you made this submission. Counsel replied that, no, this was something like that, some explanation.
Well, there is a judgment, my lord. There are judgments of the Honorable Supreme Court, my lord, saying that any submission made by a counsel beyond the pleadings may not be considered. I brought this judgment to, if lordship would like to see.
Yes, we'll see. But thing is that there might be slight variation also. If something is submitted, an order passed, chapter closed, you come up with the order saying that what is this? I never said this.
I agree to everything what
Then
you're.
person would normally, generally a person would go back and say that, I'm sorry, this is not what I had said and this is not what I instructed. Please rectify.
Correct, my lord. But I'm
coming to
the only part that your lordship, only thing that lordship is disturbed by. I approached this court little lately. But there are two parts, my lord. If I late, because of my late, if any third party right has accrued, then this review may not be accessible.
No, you can't.
It
state
has
like-
not created any third party right, my lord. High Court is the first court of records, my lord. I have to correct it. I have to. Even if I am 2 years, 3 years late, I have to correct. Lordship refused my review application, that's a different thing. But my efforts must have to be there.
All right.
That
but-
I approach this court for correction of this.
Okay, so but at least you should give the material to the court also.
I agree. with
That's what I'm saying.
I
Where is
agree.
this
I
paragraph?
agree. I
Where is this statement? Where are the
If
statements?
lordship permits, my lord, if I can bring one additional affidavit to this, my lord.
This is also an afterthought. It should come impromptu,
Yes.
isn't it?
Now, which
If
has not
something-
happened, may not
If
happen.
something happens,
For the interest
which is not against what you instructed,
My lord, for the interest of
There-
justice, lordship can do it.
normally a person will immediately react. He cannot react after 3 years and say that, oh,
My
let
lord,
me think.
What
Then come back.
my folded hand request is, my lord, this has not created any third party right, any.
Ah, that's right. You're absolutely right. Doesn't create any third party. Right?
This
It
is,
cannot.
this
it
is.
cannot
a
even
formali-
create.
This is a formality. and
Somebody
the-
else cannot get the benefit, your benefit.
Yes.
I cannot
If
take the
I do
benefit
not
of
get
Mr.
it, if I do not get it, then Mr. X will get, then my lord will raise your hands, that no,
No.
I cannot exercise it now.
That is not the issue.
That is
See,
not an issue here.
That is not an issue here.
Of course.
You're right. There's no third party right. But even if you want to claim your own right in the present circumstance,
This stringent principle that your lordship would like to apply here is applicable in that circumstance. This is a rich jurisdiction, my lord. Review in a rich jurisdiction. That too, I am praying for an innocuous thing, which
See-
has not caused any trouble anywhere.
the delay part, I think there's no such kind of decision by any court that in a writ petition, there'll be no
Let me
question
come
of
up with
being
some
delayed.
certain judgments, my lord. I will satisfy your lordship in a different.
See, even if
I
you
did
don't
not, I did
file,
not prepare it on that manner.
if you don't file a separate application for condemnation of delay, even if you don't file, at least in your review petition,
Yes.
there should be some
Right, right.
explanation. These are
Correct.
the things why I've come.
Correct.
And so, since this is a writ petition, I may not file a separate application, but these are the explanations.
My lord, right.
So another
If
circumstance,
lordship allows me, my lord, then I will file an additional. And I will satisfy your lordship on the next date as far as the, this aspect, my lord, when there is this stringent, application of law in case of writ petitions review may not be applicable.
all right, you take your time.
My lord.
Mr. Gogoi, we'll give them some time. You have a good case, but the thing is that it should be done in a proper manner.
Yeah, right.
That's what I'm thinking.
I'll rectify this mistakes.
So that the court also has some handle.
My lord.
Because of this will happen like that.
On the merits, my lord, we will also argue.
Yes, definitely. We'll hear you also, Mr. Gogoi.
It's a afterthought, my lord,
Huh.
that lordship has stated, my lord. After we have acted upon or complied with the order,
Huh.
now he has to come up for review.
My
At
lord,
that point of time, he wants a resignation to be accepted. That was his only prayer. And I was a counsel when the writ petition was disposed of. In the open court on instruction, the counsel said that he doesn't want any financial benefit. Only the resignation should be accepted.
but even if, my lord, even if that accepted, my learned friend's argument is accepted, my PF money, you cannot hold it up. This is a criminal offense. This is a criminal offense.
Okay. Mr. A. Chomo, learned counsel appears for the petitioner, and Mr. B. Gogoi.
But-
Learned Standing Counsel.
But additional AG, my lord.
Learned Additional AG appears for the respondents. On the prayer of Mr. H. Amo, Learned Counsel, matter stands adjourned for 2 weeks to enable him to file an additional affidavit.
Well,
All right.
I'm obliged.
Where's Mr. Biswas? Not present. None appears for the petitioner when the matter is called. For the ends of justice, list the matter again after the ensuing puja, Bihu vacation.
Please, Your Lordship.
Yes.
My lord, conducting counsel is on leg on court number 5, my lord.
Who?
B. Pathak, my lord.
B. Pathak, Bibhash.
Yes, my lord.
Is he ready with the matter?
My lord, otherwise he's on leg, my lord.
He's on legs, but is he ready with this matter?
He's ready, my lord.
You are there?
Pass over for the time being, my lord.
Okay. What is the matter, Mr. Gogoi?
The last matter. He's claiming lordship. Reverse lordship. Released from the service of medical grounds. He is claiming that his voluntary retirement should be considered.
To be considered. And what is your stand?
We are already releasing on medical ground before 6 months course. And he is
Okay.
getting all the pensionary benefit as well as all benefits he is getting.
On medical ground. He wants to be released on voluntary retirement.
Yes, retired on medical ground.
Medical ground.
The ground of his PR is for lordship. His PR is for
What is he? He's a constable.
lordship.
What is the medical ground? Some
Categorized.
categorization is there.
Lordship. PR is for lordship, voluntary retirement lordship from 1st of November 2020 lordship. And he was released from service on 19 February 2020 lordship.
On which date?
On 19 February 2020, he was released from service. Lordship.
February.
February. And his claim is that he should be lordship retired on voluntary retirement from 1st
January.
of November 2020.
1st of November. So before November,
For November, he was released. Lordship.
for a few months, he will retire on medical ground. And if his prayer is allowed, after a few months, he'll be again released on voluntary retirement.
Already he is getting all the pensionary benefit and everything.
What is the difference? Some more benefit is there.
He will get the salary at the relevant, but some financial benefit will be.
Some more financial benefit is there if it's voluntary.
Otherwise,
see.
no, given will be also not.
What happened to him actually?
No, see,
What is his medical condition?
medical condition, no, see, it is there, we have an next option. Is P2 permanent lordship 24 lordship, case 24 itself lordship, P2 permanent.
Page 24.
24 of our activity.
24 your affidavit.
Lordship.
So what does it say?
If we going now recommended is in 2013 law, 2013 onwards, no, see, we have annexed the lordship medical documentation.
No, what is the medical categorization?
Is P2 permanent lordship. It
P2 permanent. Where is it?
is page 31 also. 31.
In page 24, isn't anything like that?
Page 24 also lordship. Page 24,
Where is that? P2.
P2 lordship,
P3.
P3 lordship,
P3 or P2? P3.
P3 lordship,
Which one is worse? P3 or P2?
P3 lordship.
P3. No, actually, what is his condition? Seizure.
Lordship, lordship.
He's in the habit of having seizures.
Lordship may kindly peruse page 47 lordship, summary opinion of the lordship commander.
47.
Page 47.
No, summary opinion means it should have been by the medical officer. Commandant, what will he do? He says alcohol dependency syndrome.
It's based on S5 nursing. In view of the all above, last paragraph, considering the instruction of a medical examination and classification of person and CPMF issued by ministry's letter. So recommended to be placed on S5 and invalidated out of the service of alcohol dependent syndromes and subject to the approval of so.
So it's related to alcohol, not any such kind of deformity or something like that. So what to do?
So last any posted after vacation was otherwise last matter. I have no objection, otherwise they can make a statement.
There's one more matter, item 22. Anyone is ready? No.
No.
You are enjoying pension, medical pension. It's not that you're not getting any pension. We can have it after the vacation. Mr. B. Pathak, learned counsel for the petitioner, is said to be on legs in a different court. And therefore, on a prayer made on his behalf, matter stands adjourned to be listed again after the ensuing Bihu vacation.
When was the medical recommendation part is also there, page 45, same issue, same part. And all the pensionary benefit and others, he has already withdrawn.
Okay.
Plus.
Then 22. Item 22.
Mobilized.
Have listed also ensure as a readable ensure that relevant records between the proceedings are kept available for person of this board is required. Then BP. Okay, none appears for the petitioner when the matter is called. You are there in this case? Okay. For ends of justice, list the matter again after the ensuing Bihu vacation. It's a DP matter. Anyway, I think that's all.